Yeah, that's right.
Right. And I got to know Joe in previous role at the FTC when he was head of the Bureau of Competition. So I'm really delighted to have Joe talk to us this morning.
It's great to be here.
Both of the FTC's core missions, the consumer protection mission and the competition mission, implicate tech issues. So I wanted to start first with a few questions about the competition mission and from the competition perspective. So earlier this year, the FTC's Bureau of Competition launched the Technology Task Force, which was recently renamed the Technology Enforcement Division. And can you tell us why you made this change and what the TED's agenda will be going forward?
Sure, be very happy to. So our mantra is vigorous competition, both on the merger side and on the non-merger side, on the conduct side. So where do we look for conduct cases? We look for conduct cases where there is likely to be substantial market power or monopoly. And, of course, the big tech platforms clearly fit that bill. In addition, these platforms are growing larger every day. They're huge. They impact millions and millions of people. And they are a very important part of the economy, so that if there is anti-competitive conduct going on in this sector, it could conceivably have a very significant negative impact on consumer welfare. So those characteristics mandate for us that this is a key focal point and a key area of emphasis. Also, it's a very complicated area. These industries are complex. The double-sided platforms add to that complexity, but then even above that, they're complex, and to a large extent, they're opaque. So creating a new section allows us to focus our resources on a very significant priority for the Commission. It creates a situation where we can have knowledge acquisition and diffusion, and increases the efficiency of doing that by having a single group that's focused on this industry and not distracted worrying about other things. And the last time I was at the Commission, I was the Bureau Director, and we started a new section then to deal with hospital mergers, which turned that program around. And so we thought we would try something similar this time and hope for the same type of success, and I think so far the results are pointing in that direction.
Well, and I love your acronym, because then everything they say is a TED Talk.
Yes.
So they can... So does TED have the resources that it needs? We're always operating in a resource-constrained environment, and it's a big task. So give us some views on that.
Sure, absolutely. Let me just say before I get to that TED's agenda going forward is to focus on the conduct side, but also to focus on the consummated mergers, and that can come in multiple different flavors. So one flavor is a single acquisition that's been consummated and may itself generate anti-competitive effects, and then also to look at a series of acquisitions that can generate more anti-competitive effects or multiple or cumulative over the series of effects, and then also to consider whether there is a campaign of exclusionary conduct that's going on that includes exclusionary behavior like exclusive dealing, loyalty programs, tying, things like that, combined with a merger program. So they're looking at all of that. The other thing I would say about TED is, and what their agenda is that they are. We can say publicly that they're investigating Facebook because Facebook disclosed that. And so when that happens, we traditionally have confirmed that that's what's going on. We can't talk about the details so much, but I also want to say that that TED has, in addition to Facebook, multiple other investigations going on of major platforms. In terms of the resources for TED is just stocked with an incredible group of people who are bright, energetic, and hardworking. And they're working really, really hard. They're burning the candle at both ends, and I think they're going to be very, very successful. But having said that, we were asked by the Hill what we would do if we got more resources. And one of the things we told them that we would do, depending on how much resource we get in addition, would be to double the size of the TED, not only in terms of the lawyers there, but also in terms of the technologists. TED is about to hire, or in the process of hiring, 2 technologists to add to its staff. And if we had more money, we probably would increase that as well. And then in terms of what would the impact of that be, I think TED is situated to be extremely successful as it is right now, but it is limited. And so if we got more resources and doubled the size, we would clearly have additional investigations that we could pursue and likely additional enforcement actions. So just as a kind of a bottom line, more money is likely to produce more enforcement actions.
Well, even with the resources that you have, certainly the agency's been extremely, extremely busy and productive. And you just recently concluded your 21st Century Hearings series, led primarily by the FTC's Office of Policy Planning. As a former OPP director myself, I know what a monumental task it is to synthesize all that information that the agency gathered over that really wonderful series of hearings. So, of course, we're all eagerly anticipating the output from the hearings. And what can you tell us? Give us a little preview about what.
Sure. Be happy to do that. So, but first, I want to come back to what you just said about your prior stint at OPP. And hearings of this magnitude are really an incredible effort done not only by the people in OPP who did a terrific job, worked incredibly hard, but also lots of other people in the Bureau. And they really deserve a huge thank you on the job they've done so far. And now they're invested and working and getting the output together. So I'm very much looking forward to that as well. In terms of what we can expect, and of particular relevance to this conference, we're planning to issue a guidance document on platform competition. And just to give you a sense of what that might look like, if you were to go look at the competitor collaboration guidelines, our intent is to have the platform guidance in a similar format to that. We're also planning to issue a vertical merger commentary along the lines of the 2006 commentary on horizontal merger guidelines. And we're developing an addendum to the 2006 horizontal merger guidelines that we expect to deal with nascent competition, nascent competitors, and also to show how we analyze non-price aspects of competition, quality factors, and innovation, potentially privacy as well. We're also going to do our best to put out vertical merger guidelines. We'll see how that goes. No promises there. And we're looking closely at the what was produced during the hearings on common ownership and the economic literature surrounding that. And we're considering whether that material would cause us to change policy going forward. And to help us along that way, we're also considering doing a 6B study on that topic. Finally, we're going to take a fresh look at the consumer welfare standard and alternatives to that standard, and we expect to have some output on that topic as well.
So let me ask a follow-up question on the platform guidance document. To what extent do you anticipate that it will break new ground or change the status quo? Sure.
So it's really interesting. This conference is one example of this, but there are conferences all over the place that are dealing with the digital world and digital platforms in particular. And you can understand why it's high importance. The agencies are both investigating this. There's lots of activity surrounding this stuff going on in Europe and elsewhere. But in terms of how we look at these things, platforms have been around for a really long time. I mean, you go back and the ones I think of initially are newspapers. Those are multi-sided platforms. Then we had radio develop, another multi-sided platform. Then we had broadcast television. Then we had credit cards beginning in the 60s. We had Microsoft, which is now 20 years ago. And then we had, on the economics side, we had an explosion of literature dealing with multi-sided platforms beginning about 20 years ago. And even on the legal side, you have the Lorraine Journal case back from the 1950s, I think, which was one platform competitor, the dominant newspaper, refusing to deal, engaging in exclusionary conduct with respect to the new technology at the time, which was radio. There have been lots of antitrust cases dealing with these issues. There have been lots of antitrust cases dealing with credit card industry. I mean, personally, I've been involved in my private sector career working with MasterCard for about 20 years on and off, defending them in various antitrust suits. And so this has all been going on. And, of course, it's lately risen to the Supreme Court with the Amex decision. So my sense is that these issues aren't so much brand new. They've been out for a long time. And I think what we're going to try to do is we're going to try to create a synthesis of them in a way that puts it into a nice structure and provides guidance about how we're going to go forward with enforcement in this area.
So you had also mentioned the competitor collaboration guidelines as a model, and those were joint with the FTC and DOJ. So do you anticipate that the platform guidance will also be a joint FTC-DOJ effort?
I think we're going to try to have this be a joint effort with respect to all of these things. They're statements of method of analysis and enforcement intention effectively. And so, ideally, we would like to be on the same page and speak with one voice. And so we're going to try very hard to do that.
Great. So I want to be sure we get a chance to talk about the FTC's consumer protection work on the tech side as well. So I'm going to switch gears to that. So just about everyone in this room, I'm sure, has heard about the FTC's recent record-breaking privacy settlements in the Facebook and Google YouTube matter. But those settlements have also faced a fair amount of criticism. So how do you respond to the critics?
I respond in multiple ways. So first of all, for some context, we are enforcing a statute in the privacy area. Our basic authority in the privacy area comes from the FTC Act. Not entirely, but primarily. Our privacy program is based on the FTC Act, and in specific, our deception authority. That statute, of course, is more than 100 years old and clearly was not designed to deal with the privacy issues that we are facing today. And I have to really give a huge shout out to my predecessors at the FTC going back 20 years, who effectively created a very significant privacy program out of whole cloth. They took a statute that was not designed for this purpose and figured out a way where we could have an impact and be very active. But our tools are limited. We don't have the authority like the Europeans do to enforce something, at least not yet, like GDPR. So it's very important to keep that in mind when you think about our enforcement efforts. So specifically about the aspects of the Facebook settlement, $5 billion is a lot of money to anybody. It was, and even to Facebook, it was 9% of their prior year's revenues. And if you look at the GDPR, it's still kind of new and they're subject to interpretations, but it's arguable at least that their maximum fine is 2 to 4%. And if that were the case, our $5 billion would represent more than twice their maximum fine. And then in addition, Facebook's, the $5 billion is 22 or 23% of Facebook's profit. Now, some people have said, gee, they have so much money, that's just a parking ticket. But if you think about this in kind of everyday terms, and you think about someone who, let's say, makes $60,000 a year in annual income, 9% of that would be $5,400. And for those of us who make more than that, $5,400, even for those of us who make more than that, $5,400 is still a huge parking ticket. And I don't know about you, but it would certainly change and alter my behavior in terms of where I parked if I was subject to a fine of that kind of a magnitude. And the fine is big and significant in and of itself. In fact, it's one of the largest fines in U.S. history for any type of violation. It sits there right up with huge environmental catastrophes, BP Horizons, and enormous financial frauds involving banks. So by any measure, it's up there. The other thing, too, is the trade association for the privacy professionals did a really interesting graphic. They took a ball and sized it for our enforcement efforts at the FTC in terms of fines that we collect. And it took the fines of every other privacy enforcement agency on the planet and added them up. And ours just totally dwarfed theirs. So we are arguably the biggest enforcer on the planet. So that's on the fine level. Then we also had very significant injunctive relief. Now, some people have criticized us for that because either we didn't cause Mr. Zuckerberg to divest his shares or give up control of the company, or even more drastic, divest various parts of Facebook itself. So we don't have the authority to do that kind of a thing ourselves. But what we were able to do in the consent negotiation was to get Facebook to create a new board committee composed of independent directors who are responsible for privacy. We didn't get Mr. Zuckerberg's name in the caption, but he signed the order, and his name is in the order, and he is personally responsible for certifying their compliance with the privacy program quarterly and overall with the order annually. And he can't just hide his head in the sand. He gets mandatory information flows that are set up by the order. So this is, and then the other thing that the order requires is that for every new product, service, or practice, or a modified product, service, or practice, Facebook must effectively create what is a privacy impact statement. And this all goes to Mr. Zuckerberg, and it goes to the board committee, and it's available to the FTC. And this is an effort to create privacy by design within the company and change their culture. Now, so the order in and of itself, I think, just standing there by itself is extremely good. But when you think about what our alternatives were, there was just no choice whatsoever. The alternative for us were two. We could go and negotiate the best consent we could negotiate, or we could go to court. If we went to court, we would be litigating for years. 3, 4, I don't know how many years, especially if you include appeals. And I think overwhelmingly people who are experienced in this area understood, or still understand, that if we had gone to court for a period of years, we could have lost. But even if we had won, the chances that a judge would have ordered anything even remotely close to our settlement terms is very, very low. And I think that's even the case if we had gone through litigation, more discovery, and come up with, say, double the number of violations that we had in the complaint. I think we still wouldn't have come even remotely close to the relief we got. So, and then another thing to think about as well is once our order, our negotiated order is signed by the court, which we hope will be very soon, if Facebook violates the order, we're then in a position to go back to the court and say, Judge, $5 billion was not enough. This injunctive relief that we got here, including board restructuring, was not enough. We need more. On the other hand, if we go to litigation, it's years down the road before an order becomes final, and then we start from a much lower baseline. So in that circumstance, if they violate the order after litigation, then we have to say to the judge, well, Judge, whatever you order in terms of the fine, say $500 million, that was not enough, and you need to give us more, and we'll be way behind where we would have been had we taken the consent decree. So for me, at least, I think there was no real alternative. Our enforcement division staff negotiated a terrific decree, and given the choices available to us, this was really the only path forward.
No, well, thank you so much for that. And unfortunately, I mean, these topics are fascinating, and but we need to wrap up. And I just want to say thank you so much to Chairman Simons for sharing your views on this. I really appreciate it. Particularly found it very interesting to hear your thoughts so much on the Facebook settlement, and I thought that was really, really illustrative and very, very helpful.
Thanks so much. It's always a pleasure to be here with you, Maureen.
Oh, thank you, Joe. I appreciate seeing you as well. All right. Well, thank you, everyone.
All right. So why don't we cue up the video, and we're going to get the data as an asset panel on the stage.